hand it over to Sasha from ENS Africa, who happens to be one of our EMEA co-chairs for the infrastructure group and is also with one of the firms that is presenting today. So I'm going to go ahead and hand it over to you, Sasha.
Thanks, Hannah. So on the agenda today, I've asked one of our colleagues from our Namibian office, Wolf Wallace, who's on the call, just to give us a brief update on one of the exciting green hydrogen projects that he's working on. Just to briefly introduce Wolf, he's an executive at ENS Africa, our firm, based in our Namibian office. His areas of specialty include corporate commercial, banking and finance, and mergers and acquisitions. Wolf has represented clients in a number of industries, including the mining and petroleum industries, and his experience includes advising clients on matters relating to mining, petroleum, energy, mergers and acquisitions, and contracts, as well as general corporate and commercial law. Wolf is recognized as a leading or recommended lawyer by IFLR 1000 Financial and Corporate Guide, as well as Chambers Global Guide and Who's Legal over a variety and a number of years. So Wolf, let me hand it over to you to then discuss the green hydrogen project that you're working on.
Sure, many thanks. And I just, first of all, I'd just like to wish to apologize. I was brought into this matter at the last minute because John had some other commitments. I've tried to prepare as much as I can, being involved in this specific green hydrogen project. My background, we are in Namibia, just to add on to Sasha's introduction, we are a bit more jacks of all trades in Namibia. My claim to fame probably is more on the mining, energy and petroleum side. But yeah, you have to do a little bit of everything. So don't put too much into the CV. But anyway, so we are at the moment very actively involved in the green hydrogen project, and maybe I can just give some background first. So the first moves or the first interest that we received on green hydrogen, and I must confess to you, I'd never heard of it before March 2021. That was when an Australian, potential Australian investor, quite a large group, came to us, and they started asking about becoming invested here. At that stage, there was absolutely no framework, no legal basis, no knowledge. There was nothing with regard to green hydrogen. So they literally came to Namibia on a complete, if you want to use mining lingo, on a greenfields basis. They had absolutely no idea what they were in for, and neither were we, because there was nothing. There was absolutely no legislative framework, nothing whatsoever to rely on, just rudimentary laws and trying to identify how one could do this in the Namibian context. Now, for those who don't know Namibia, we are a developing nation, and also I don't know to what extent our experience really has any value for the members of WSG. We are a third world country. We're a developing nation. We have a very high Gini coefficient. There is literally no industrialization. Whilst we were part of South Africa, most industrialization took place in South Africa, whether by design or not, I don't know. But certainly Namibia was never before independence developed. And while we had all of these wonderful plans from our government on Vision 2030, none of this has actually come into fruition. So essentially, we're living off, and we're dependent on agriculture, on mining. We're exporting the raw materials as opposed to beneficiated materials. We're doing some fishing, and we're dependent on tourism. That's probably on the service level a bit more of our high value, at least on the services side. So, and other than that, Namibia has got a very small tax base. On the upside, and look, I'm a Namibian with heart and soul. I will not say bad things about my country, but we've had a stable government. You can call it a dominant party. We can call us a dominant party state, but we've had a kind of a vibrant democracy, although the opposition doesn't really have that much to say. But the courts uphold human rights. We have a very sound principle of the rule of law, which the courts uphold. So there's ups and downs, but overall, we are living in what you can fairly describe as a constitutional state, as good as it gets for Africa, I guess, taking into account the difficulties that you have in Africa. So nothing that a lawyer like me would have to pack his bags and look for greener pastures. Yeah, I just want to point that out, because this is quite critical, because we saw a lot of these issues in dealing with the potential investors. They come here with certain attitudes, which unfortunately are then also either met by resistance by government, or they're unrealistic. And that's, I think that's an important part of the experience that we can share, at least from a developing nation, African developing nation point of view. Okay, so that is now, John asked me to address the issue of what's the legislative environment and what do we have. So in essence, our experience is we have Article 100 of the Constitution. I'd like to point out our Constitution, some of you may recall, when we achieved independence in 1990, we were a child of the United Nations. There was this United Nations resolution, and in essence, we had a constitutional assembly which had all the people of Namibia voted for in free and fair elections, decide on a constitution. There were a couple of principles, very Western principles, and at the time that the Namibian constitution was drafted, I would say before the South African constitution was drafted, we were probably the most modern constitution, because it had been designed in one big go. It wasn't a constitution that came about over years, but it was one constitution that came together in a couple of months, disciplined, working with advice from public international law lawyers, from constitutional experts and everything. So in Article 100, we then stated that all the natural resources of the country belong to the state. Now, Article 100 is not so much as a principle of fundamental law as it is a principle of state policy. But there's a court case from the Supreme Court where the Supreme Court kind of elevated that as if to say that this principle of state policy is kind of a statement that the state is the owner of natural resources. I don't think it's true. I don't think the Supreme Court was entirely right in its wisdom, and it's not handled like that in practice, but that's out there. So what have we regulated since? Based on that, we've essentially regulated water in terms of some old statute. We've regulated minerals and petroleum. So we've got a Minerals Act specifically dealing with minerals. That's maybe of interest for our Australian friends on the call. It was very much influenced by some Australian consultants who brought us quite a modern Minerals Act, taking into account that minerals are not land rights. They do not belong specifically to the landowner, but they belong to the state, and you have to find some other way to get to that. And a similar thing in petroleum. The Petroleum Act is maybe not as properly, it seems it was made in a hurry. It's a bit thin, but in essence, what is not regulated and what proved to be an immediate problem in this matter was there's no regulation in our law with regard to solar, or the power or the resource that is solar, and there's no regulation of wind as a resource. So as a lawyer and working in common law, I find that quite great, because it means you have to secure, in essence, the land to get to everything. Now, land is regulated, and I come back to the specific things of that. But so here's the first thing that our government really had to get its head around. You see, they were coming from the background and understanding that a mineral resource or a petroleum resource is scarce. Now, it is very difficult to teach a government official that the wind is blowing all year long, and in 100 years or 1,000 years, it will still be blowing, and the sun will hopefully still be shining in a billion years. So for the politicians to get out of a mindset in terms where they understood the resource to be scarce and that they had to do over licensing and all of that, that was the first really, really difficult thing to engage with in government. And I think that's hopefully something that other jurisdictions can take away also from this talk. That was also, it does require you I think from a philosophical and from a legal position to make a bit of a mind shift. I also had some difficulties with that, being used to this licensing regime and, dividing up things, looking at competition issues and all of that. So that's the first thing to understand, really, I think. And it's an important thing that we we continue, and whenever we're speaking, whether it's to financiers, whether it's to governments or to regulators, we always insist on making it clear to them that they must change their mindset, that the resources are not scarce and they will be around hopefully in 1,000 years or more. Okay, so then our principal problem was then, so what is regulated? What would stop you from a Namibian undeveloped legal framework context from doing a hydrogen project? So there's two things. First of all, it's access to land. Now, that has unfortunately a political connotation and a big political aspect to this. I don't propose to go into the details of this, but as you may imagine, because Namibia was colonized, quite a big portion of the freedom fight of what is now the ruling party obviously went around access to land, and the fact that large tracts of land, at least the commercial farmland, was what, from their understanding, occupied by what was the colonizers. So we've had some pretty restrictive land regulation, which is specific to Namibia, which I guess you would not necessarily have in many other countries, but possibly in other African countries sharing the colonial experience. So we've had some restrictive laws with regard to foreigners who may not acquire access to so-called agricultural land without ministerial consent. There's a whole license rush that you have to run through in order to get to your licenses. Now, what makes this one particularly interesting is this specific, Namibia still has large tracts of land which are unsurveyed state land. Essentially, they belong to the state. It is land that doesn't appear on a title. It doesn't appear on any title deed. And until such time as that land has been surveyed and a government title has been taken out in terms of one of the other laws, that land is basically, for legal purposes, non-existent, because you don't know where it begins and where it ends. You just know it is this piece of land and it has that status. So again, there was a whole array of regulation that was problematic here. It has to do with getting State Finance Act approvals and getting lease diagrams drawn. But that's all practical things that you could kind of get. You could get to them, but it does make it difficult, because this particular land sits south of Lüderitz. It is in an area which was traditionally mined, and worst of all, what has happened now is a couple of years ago, the area was declared a national park. I pause here to point out the irony of this, because that particular land, essentially from Lüderitz to if you look at the map, from Lüderitz to the Orange River, was essentially dug up by the diamond mines for 70 years. I mean, no stone was left unturned to get diamonds out. And then and now because it was a restricted area, how do you keep it a restricted area? You declare the thing a national park. Now that thing, unfortunately, will come to bite us at the latest when some or other equator principles or some or other financing environmental principles come to hit us when we will advise our clients to actually deproclaim the park in the area where the hydrogen project is to be given. I'll say something more to that a little later. I just want to first deal with the other aspect. So that's the one thing. So you need access to land, and there's some restrictions on that for foreign nationals, but I guess nothing that you cannot overcome with if you apply yourself, you follow the law, and if you continue digging. I guess the difficulty is the size of the parcel of land that we're looking at. It is huge. Namibia is also a pretty large country, but yes, it's still quite a chunk of land that is being required, and of course that land will be lost for any kind of conservation or maybe even historical tourism or whatever. So then the second thing that you would need, and here it becomes a bit more complicated, is we have the Electricity Act. Now, you will need to, if you wanted to establish a green hydrogen project, you will need a, believe it or not, electricity generation license. Now, the Electricity Act was written for consumer protection. It was one of these laws that Namibia introduced as part, and Sasha, help me out here. I think it was part of the bigger SADC white papers on establishing regional electricity suppliers and all of that. Essentially, Namibia, as I understood it, with our Electricity Act, we brought our laws in line with what was happening in South Africa. It was consumer protection legislation. That's my understanding. Essentially, you get tariffs, you get independent power producers, where previously you had a monopolist like in South Africa, Eskom, or here in Namibia, Swabek, or now NamPower, who produced all the power. So the Electricity Act is wholly unsuitable for supporting, as far as I'm concerned, is wholly unsuitable for supporting a green hydrogen project, because generation of power is just a portion of that. It's just an element of that. And because, I mean, you really don't want to get unbundling are no issues here. You will produce electricity for yourself for an industrial process, not for consumption to producers. You shouldn't need transmission licenses. But anyway, so that is there now. So you're sitting now with the Electricity Act that is not written for this, but you will need to tick these boxes and obtain relevant approvals under the Electricity Act. Okay, then the third issue that is a problem is there's, of course, very little experience with occupational health and safety outside the mining sector. Now, I'm not a hydrogen expert, but I was, from what I've worked on so far, I'm given to understand that hydrogen can go boom, and so there would be some safety issues, and I assume there will have to be some other framework developed for the transport, the storage, and general safety issues in operating a hydrogen generation plant and transmission lines or pipelines or whatever you're dealing with there. So that is also wholly undeveloped in Namibia. Okay, now turning to some of the political things. The other thing, which was, and maybe it's a Namibian problem, the other thing that turned out to be quite challenging was because for that first Australian investor, they came here and they essentially flew in with their private jet, and they had a meeting with the president, and they brought their foundation from Australia to Namibia, and the expectation and the understanding clearly was that it was a bit of a first world investor's attitude towards the third world. It's like, we come here and the president makes a decree and we'll have a project tomorrow. Now those illusions were terribly shattered within I think the first 2 or 3 weeks. First, they wouldn't believe our advice, and then secondly, they started then dealing with the Namibian government, and then they realized that decree is not forthcoming anywhere. And the reason why the decree is not forthcoming is what I said at the beginning. We are a constitutional state with all its faults and with all the difficulties that you have in an African context, but we are a constitutional state. The legality principle is alive and well, and different to Kazakhstan. And in fact, we were handed a draft agreement that this particular company had entered into in some or other former Soviet Union republic. And we just had a good chuckle at it and said, well, you can try your luck with that. That's not going to work. So the takeaway from this is, I do think, and it's not, I'm not wagging my finger at first world investors. I'm just saying, I do think there's a big misunderstanding in many ways. And we see that a lot from first world investors, even financiers, when they come to the third world. They think these projects can be done by decree. And that may be the case. That may be the case in countries or former Soviet Union countries, or maybe more authoritarian countries. I very much doubt that this is possible even in Zimbabwe or in Angola. I mean, even the Southern African countries, at least from our experience, we do have a rule of law, and it may be more or less pronounced in different countries, but it's there. There's legal principles. There's the principle of legality. So I think that's to us at least, a very important takeaway, because our experience was that our investors would not listen to our advice until they got to the hurdle of actually dealing with government itself, and then they realized we were right all along. We told them so, because even a president in Namibia will ultimately say, well, you can fly in here with your private jet, and you can take it to bring your foundation here, but we'll take it to our attorney general, and we'll have a look at this, and we'll consider what is and what is not possible. So, and that then unfortunately ended up in this specific project and ending up in a tender process, again, for which our Public Procurement Act was not really written. And I don't want to go into all the details of that. There were a couple of administrative blunders there from our government, quite serious administrative blunders, which as my colleague Hartmut Ruppel called it, is sort of like a bit of like a poisoned fruit. And it's something that we're still dealing with. In essence, to make it short, it has to do with the fact that they didn't follow the right procurement process. It's a matter that has now been resolved, but it has been resolved actually quite coincidentally, not by design. It just so happens that a couple of years ago, when we found that out now, the government had actually given an exemption on the disposal of assets such as land, which is what you require from government. Sorry, Chris, I see you're putting up your hand. Am I talking too much? Chris, I can't hear you. You're on mute. The hand is there, but the microphone is off.
And Wolf, not that you're talking too much, we usually allow people to raise hand or drop questions in the chat throughout. Go ahead, Koos.
You asked for this. I'm not finished yet.
Koos, I think you're still on mute.
Koos, move your mouse, bottom left of your screen.
Of course, you can do
You
it.
might be having some. Go ahead, Wolf, and we'll see if he unmutes himself.
If Koos can't interrupt me, everything is fine. Okay, so like I'll try to wrap this up now quickly. So then we had a couple of issues with ministers jockeying for position, and there's of course always the concern in the third world that if different ministers which have sort of overlapping.
Sorry, I don't know, there were some technical issues on the sound. Sorry. I just wanted to ask, maybe for the other participants on the Zoom session, just to tell them a little bit about the project itself, the dimension elements of the project, functionally, the size of the project, the timeline, the client, I think, is Hyphen, and also, you know, what elements are contemplated of being sort of done in Namibia. Sort of hangs together with the international market.
Okay, my apologies. I wasn't sure to what extent we could speak about the clients in this matter. So the client is Hyphen, and they're backed up by a German company. Hyphen is a South African company, as far as I know, but I don't know who Nicholas Holdings is behind it. I don't have any details of that, but they're backed up by a fairly new East German company called Enertrag. And I understand that Enertrag also produces electrolyzers, and I think that was ultimately the reason why they were sort of given the preference to prepare this project in the areas, because one of the important things for the government was to know that people didn't first have to develop factories to establish electrolyzers. My apologies that I don't know the exact megawatt for the project, but it is huge. I mean, it will take up, if I'm not mistaken, almost 200,000 hectares of land in Namibia. That's basically the size of, you could say, 10 to 13 farms in Namibia. Our farms tend to be rather large, and particularly in the south. The project would then not only produce green hydrogen for export, but also ammonia. And what it would require essentially is the electricity generation by way of wind and solar, because in that specific area there's a very good mix of both solar, and it's in the desert, but it's there's a very good mix of solar and wind, the capacity you get there. And then secondly, there's obviously seawater there for desalination. So there would have to be desalination because it is the south of the country. There would be no freshwater resources there. Even Lüderitz, the nearest town, has to import its water from, I think, 150 kilometers inland, and that would not be sufficient for the project. And then the idea is to have these corridors, so that they would be producing the green hydrogen, the ammonia there, and they would then either by pipeline, I understand, or by truck. I'm not quite sure what the final plans are there. That would go to a harbor, and the idea of Hyphen is to prepare a common user infrastructure for all other projects which may in future come into the area. But essentially, Hyphen has sort of a first choice to get really the biggest and most promising blocks where wind and solar could be exploited. Is that good enough, Chris? You're on mute again.
Thank you. I also read somewhere that they're talking about something like $98 billion investment over lifespan of the project. And by the way, Wolf, I think just about all of what you've just described is available online. But it looks like a project that's probably going to span over the next 3 to 5 years.
Yeah, that's for sure. So, yeah, okay. So, I'm sorry, I can add something on that. So, the idea is for them to run basically what you could call it a pilot plant. They want to. The government calls it a feasibility study, which I don't think is quite right. But in essence, they want to put something up there for 2 or 3 years, see whether it works, and if it works, then they want to have a 40-year lease for that really large area. And yeah, so there's competing rights there. There's mineral rights there. There's a national park that may have to be proclaimed, which may still find itself that might become a real problem on the financing side. And then maybe just to wrap this up, so Namibia doesn't have any particular tax breaks in our tax laws that would make this possible. One would hope that the government would maybe have some kind of incentive, as they have in the mineral sector, which is the only sector where you can really set off all your development costs against the project, and then at times not pay taxes for years as you are recovering your investment. None of this is on the cards at the moment. We know we won't have a Green Hydrogen Act in the near future. It was something that will have to be developed. And then the big issues will be the environmental issues. Because we would be recommending to our clients to deproclaim the game park in the area where the project is situated, because the legal regime for the game park is wholly incompatible with the legal regime of running or the factual regime of running a hydrogen generation plant and doing all of these things. And also taking into account the irony that this is all diamond area, which has really been disturbed. Yeah, and then the other issue is then it is unlikely that our government will give guarantees or bonds and whatever on any of the financial commitments. That I think is just a general Namibian reality. It's not related only to the fact that the project is so large that the government would not even be able to stomach it from the size. So yes, thank you for listening to me and hearing me out on this long monologue. And if you have any questions, happy to answer them as best as I can.
I just Wolf, just very quick. I see some of the dimensions are given in this online article that I've circulated. So the project value is estimated at $9.4 billion US. Yes. They say that it will ultimately produce 300,000 TPY of green hydrogen for regional and global markets. Expected during the first phase that were completed by 2026 to create 2 gigawatts of renewable electricity generation capacity, and further expansion, which ought to be completed by the late 2020s, will see to the generation of renewable energy capacity to 5 gigawatts and 3 gigawatts of electrolyzer capacity. So that's sort of some of the things.
Thanks, Chris. Hannah, I see there's some questions. Should we take questions right at the end and let Brendan after Brendan's presentation, or do you want to deal with them now?
I think we have time for a question or two now, and then hand it over to Brendan, just so that if there are relevant to Wolf, he can go ahead and answer those. And as always, if you have questions, you can drop them in the chat. We can answer them at the end as well. So go ahead, Bernd. I see that you've got your hand up.
Thank you, Wolf. Just one question. You mentioned that there was a public procurement procedure necessary. So usually I would expect public procurement if the state of Namibia or a municipality is asking for a service or asking for something. But I understand in this case, probably it would have been the access to the real estate, to the land, that they said if they are asking for it, then we need a transparent process. So it would be, but that's my question. What was the content of the public procurement? What was procured as such? The access to this huge land.
You hit the nail on the head there, and that's exactly the problem with it. So the Public Procurement Act is principally written for goods and services acquired by a government. But then in its wisdom, one of the legal drafters, right in the beginning of the act, they wrote in also any kind of disposal of government assets. And it is sort of an afterthought in the legislation, but it is found in such a prominent portion of the law. So the rest of the law does not speak to this. It actually says any kind of right and any kind of disposal of government assets is included there, or of government property, and that actually rendered even a long-term lease over the land subject to the procurement process. Now, what we did not know, and that is what fortunately and almost magically resolved it, is that in 2017 or 18, the government, without putting it in the government gazette, they actually put a notice out where they said, well, we're actually exempting, the minister gave an exemption notice for disposal of state assets. They probably meant movable second-hand assets, but it's broad enough to cover we think it's broad enough to cover the lease as well. So, and then the other issue was, I just want to quickly mention, is the government is in the process of, we've been trying to rewrite our investment law for a couple of years, more into the Chinese direction than the Namibian, the original Namibian direction. And in the process of that, the presidency has established a investment board, and this investment board actually has no basis on which it can operate, no legal basis. But they were actually running this what they called RFP, and that was the other tricky part of it. And it's difficult to tell an African regulator or tell an African president that the authority that he created there, contrary to law, is actually in any has any basis to award any rights, because it sort of is contrary to the legality principle. But they've now come around, they've now understood what our objection was, but it took 3 months. That's the problem. So
thank you. I mean, that's absolutely clear for me, because in Austria we would use a tender process based on state aid if it's not a procurement. So we would not use the Public Procurement Act. We would use the rules for tender if the municipality sells real estate or sells a company. Yes. Then we use the state aid basic principles, which is 90% identical. But fully understood. Thank you.
The issue in essence is just bad legislative drafting. I think that's what caused it. I don't think it was. I think it was an afterthought. Someone just spread it broad when they did the final review of the law. I think that's what happened there, but yeah, we can speculate.
Thank you.
Hannah, should we take one more question from Pedro and then?
Sure, let's take one more from Pedro, and then we will hand it over to Brendan.
Well, thank you very much. It will be a short one. Wolf, I was listening to the previous question, and I recall that you mentioned that under Namibian constitution, the natural resources are deemed some sort of public property, of state property, or managed assets to be managed by the government. Well, in my country, in Argentina, this is not the situation right now, but it used to be under previous constitutional frameworks. So in that case, I understand that that's why the public procurement procedures are called in, because after all, we are dealing with what the legal system considers public assets. Am I right in this?
Well, it's a little more complicated. You see, we are, and at the risk of going into too much detail, you see, we are a so-called mixed jurisdiction, Pedro. We on the one hand, our law is uncodified common law, Roman Dutch common law, and then on top of that, we have a bit of influence of English law. So under Roman Dutch common law, and particularly in the Roman law, we would have common assets. I've forgotten what the Latin term was for that, but the air that we breathe and the water of the sea, until they made the Seashore Act, was actually common assets. They didn't belong to anyone. So that principle is still there. Now, what is interesting about Article 100 of the Constitution, it is under the principles of state policy. Now, state policy principles are not generally, you would not expect, you can't really lay a claim against a state based on the principle of state policy, or that's the understanding. On the other hand, it has a funny rider at the end where it says, unless they are otherwise owned. So even there, the drafters of the Constitution were very cautious. They must have realized there may be assets which may be natural resources in a broader sense, but they are actually otherwise owned. And can't think of maybe mineral rights or whatever, which have traditionally belonged to the state. But it's it's a little more nuanced, the whole thing, and that's why I'm saying I think that the judgment of the Supreme Court is wrong on that point.
All right. Thank you, Wolf. I'm sorry about that.
No problem.
Thanks, so Hannah. I will then hand it to you for the next part of the meeting.
Great. Brendan is from Minter Ellison in Australia. So why don't you go ahead and take a minute to introduce yourself, and then you can just jump right into the presentation, Brendan.
Sure. I'm going to try and share first of all, can you all hear me?
Yes, we can.
We can.
Okay, great. Well, thank you. This is my first time joining the infrastructure group for WLG, so I'm really honored to be here. I'm going to share my screen. I put a few slides together. So hopefully this works. So you all see that?
See it.
Okay, great.
Yep.
So my name's Brendan Clark. I'm the what we call a business unit leader of Minter Ellison's Project Solutions Group, and we're that portion of our capital markets and corporate group that deals with large industrial assets. And so we do all work on project structuring, project finance, regulation, M&A, and project financing of large scale industrial assets and government assets. And of course, we're Australia, so we're primarily focused on the energy and resource sector. I'm Brisbane based, but our team is in 8 cities, and we have about 20 partners in the space with probably close to 100 lawyers. So that's Project Solutions within Minter Ellison. So this particular project I want to speak about is called the Central Queensland Hydrogen Project. So the Central Queensland Hydrogen Project is a project being undertaken by a consortium that began with our client Stanwell Corporation. Stanwell is the largest state-owned power generator in Queensland. It is primarily a baseload generation, and its largest assets are coal-fired. But it's making a very rapid transition into a renewables footprint. So very large acquisitions at the moment of wind and solar power purchase agreements. And over the course of the last couple of years, has undergone a large EOI process to identify renewable energy assets in which it's proposing to acquire equity. And we've been involved in helping them expand their portfolio in that way. Among the projects they want to build is what will become the largest hydrogen production facility in Queensland, and it's to be coupled with a large liquefaction and loading terminal, all to be developed around the Port of Gladstone in central Queensland. The partners for the project include Iwatani Corporation, which brings a liquefaction and an unloading technology benefit. Kawasaki Heavy, which is very much involved in the shipping of hydrogen. Kansai Electric Power Company, or KEPCO, which has end user interests in Japan, Marubeni, and the Australian infrastructure business, the APA Group, and they're one of the largest gas pipeline operators in Australia, very interested in expanding its business away from pure natural gas pipeline into a broader business. So the aim of the project is to export renewable hydrogen to Japan. It's largely based on the Japanese ambitions under its hydrogen laws, or hydrogen strategy, and then also supply large industrial customers in central Queensland with their emissions reduction intentions. So the project will have a first phase that will be active by 2026, but will scale up to 3,000 megawatts by the early 2030s. It's expected that it'll bring 5,000 new jobs to the central Queensland region, deliver 4.2 billion in hydrogen exports and 10 billion in gross state product over its 30-year life. So a little bit about the region. Central Queensland is really blessed, I think, for a hydrogen project. The region in the last 20 years has been quite famous for its coal exports, metallurgical and thermal, but also it's the home of $70 billion worth of LNG infrastructure that saw its first gas export in, I believe it was 2014. When coal seam gas to LNG became a mainstay of the region, the whole state and actually the whole country had to rapidly respond to the development of new regulatory regime to suit coal seam gas to LNG, and everything from competing land access rights, competing tenure interests, water regulation, and basically, the safety and industrial relations infrastructure, regulatory infrastructure that was needed to support it, was developed in really short order. And so the region is actually quite used now to rallying the efforts politically to respond to the development of a new industry. It also, I think, because of the world's turn towards energy transition, it's a region that's actively seeking to diversify its economic base and create jobs in the renewable sector. So all of that is making it ripe for investment in green hydrogen. Its location has many advantages from a resource perspective. High quality renewable energy is available. There are great wind resources, and one of the I think Queensland has the largest grid scale and behind the meter solar uptake in the world. Access to water, in this case fresh water, which really helps meet the price expectations of hydrogen as a competitive fuel to LNG in Japan, because there's less energy consumption without having to demineralize seawater or desalinate seawater. There's a fair amount of available industrial land, a lot of which has been sidelined by the state government for purposes like this. And then, of course, port access through the Port of Gladstone. One important point of note around this area of Queensland is the proximity to the Great Barrier Reef, and Australia has taken strict steps to reduce the development of new ports along its east coast. Really, new development is restricted to expanding existing port facilities by adding berth and doing very careful dredging within very well prescribed limits. And because Gladstone has already got a large multi-commodity port that's handling LNG and other commodities, it's ideally suited for adding LNG. The port itself is handling more than 30 different products, and among them is an existing ammonia terminal at a port terminal called Fisherman's Landing. So there's a port state development area at Gladstone that includes 27,000 hectares of land that's dedicated for industrial development and materials transportation infrastructure. 13,000 hectares of this land is designated for high and medium impact industry, and that minimizes the environmental and social impacts of the project and reduces the environmental hurdles that's required for the project to be cleared. Because it's within a state development area, we can fast track a lot of the government approvals through a coordinated development process through an office of the Queensland State Government called the Coordinator General, that's specifically developed for the purpose of ensuring that we have an efficient regulatory process for large impact projects such as this. We can also make use of some of the infrastructure that's has been developed, particularly infrastructure corridors for pipeline and rail that were developed for the LNG export industry. So the key elements of the project, essentially one is renewable energy input straight into the power distribution system, Although as it's developed, I'll speak briefly about the fact that the power supply is likely to be over the fence for the most part. In other words, it won't necessarily be sourced through the existing power grid, but rather through a direct connection to a large solar facility. Water supply and water distribution will then be brought in and combined with the power to a hydrogen production facility. It'll then be pipelined to a liquefaction facility that also has an ammonia component and a liquefied nitrogen delivery to provide for the liquefaction. It'll then be transported to an export terminal for shipping and shipped to Japan, where an import terminal will be developed, and the hydrogen will be shipped for use in power plants and distribution for other uses such as fuel cell, and even delivery to the stovetop, basically. The project itself, phase one, is looking at 100 tons of hydrogen production per day within the next 3 to 4 years, and that will then scale up rapidly within the ensuing 5-6 years to 800 tons per day. At the moment, the project's in a feasibility stage, and that the feasibility report is in draft already, and the results are promising. But the feasibility was all driven towards finding ways to bring the price down to be cost competitive with the landed import price of liquefied natural gas in Japan, so that the hydrogen is actually cost competitive with its I guess with the most attractive and lowest emission alternative fuel. So that was the whole aim of the feasibility was achieved at identifying the best mix of wind and solar, reducing transmission charges through our national electricity grid was a main focus. Those distribution charges can be quite costly, and I think it's one of the the forgotten aspects of our transition away from baseload fuels into renewables, is that in Australia in particular, the way our power grid is structured is that as we add renewables to the power grid, particularly non-spinning generation solar, we destabilize the grid, and the grid infrastructure has to be redeveloped to accommodate wind and solar being added to it. That is significantly increasing the cost of our transmission network, and those charges are being passed on directly to consumers. And so avoiding those charges, or at least minimizing them, is a key to bringing that landed import price of hydrogen down. The feasibility study then was looking at ways to reduce the electrolyzer expense through competitive original equipment manufacturer engagement, efforts to improve the efficiency of the liquefaction technology, and then of course reducing shipping losses, all of which was also aimed at trying to find ways to entice the governments of Japan and Australia to support the project through policy mechanisms. So some of the key milestones for the site, this is what it's intended to look like, superimposed over the actual site, and you can see it's proximate to highway and rail. But in this region here on the left side, this corridor is actually where 3 of the major gas pipelines are located that bring coal seam gas to the Port of Gladstone for liquefaction and export from the Stratton-Bowen Basin. So we have existing pipeline corridors, existing rail infrastructure, and proximity to very reliable renewable energy resources. So in June of last year, we secured an option to purchase with Economic Development Queensland, which is the owner of land at the site, for a 236 hectare site. That is just for the electrolyzers. The actual power was or is intended to come, and we have an MOU. We're in negotiation with Acciona for a connection to the Aldoga solar farm that's to commence construction next year, and that will provide that direct solar power to the electrolyzers. And then feasibility study funding was secured from Australia's Australia Renewable Energy Agency, or ARENA, and feasibility funding was also then provided through the Japanese Ministry of Economy, Trade and Industry. So we have strong government support right from the outset of the feasibility. Just briefly, I think some of the legal challenges, and I've put into this slide, and I think I want to start by just emphasizing the relationship we have with Stanwell Corporation from the outset. And I think we've been their primary external counsel for I think I've been leading that relationship for over 12 years now, and it goes beyond that. And we have been advising Stanwell on all aspects of its business for a number of years. And I can't, I think, overemphasize how much of a benefit that has been in helping them transform their business and move into something so novel as a hydrogen project of this scale. It's required an understanding of how they relate to government, how they procure power and how they sell power, how they develop projects and make decisions, how they deal with their employee base and their industrial relations concerns. It's all been kind of critical, and this one project has brought that to the fore or brought all of those areas, I guess, to bear, and it's been I think it would be very difficult to help them advise on this, or to advise them on this project without such a complete understanding of the totality of their business. And we've been quite fortunate then to be able to act not only for Stanwell and sort of bringing the consortium together, but then to continue to act on behalf of the consortium as they have developed the project through the feasibility funding phase. So one of the, from a structuring and financing perspective, we're faced with different consortium members who bring different strengths and different interests to the project, and they've all got different interests on of the infrastructure. So we're expecting that ownership interests will differ as between the hydrogen production facilities, the hydrogen transportation facilities, and then the liquefaction loading facilities. And yet all of that that infrastructure is highly interdependent. So really important that the front end engineering and design and the ultimate construction scopes are, that there's coordinated development of those scopes so that the infrastructure is dependent on one another. I guess a key aspect of financing a hydrogen, there is no spot market for hydrogen. So a committed offtake arrangement is critical. That means that that produces the hydrogen really has to marry the plant that liquefies and loads the hydrogen. The hydrogen purity, the delivery schedules, the production schedules, they all have to match well with the shipping schedule and the ultimate customer demand for the hydrogen. So we have largely been working to develop a contract template around which they can create a project development agreement and funding arrangements so that they can go into a coordinated final investment decision. All of that is really based on a gas sales, gas transportation, and then a liquefied gas sale and purchase agreement. And then we try and develop hydrogen specific contracts based on understood contracting mechanisms for gas. But through that process, we've learned a lot about the difference between hydrogen and your typical natural gas contracts. And I guess the real key to that is that unlike the case of natural gas or CH4, where there is a spot market and there are alternative producers and alternative off-takers, there is no existing market of that nature for hydrogen. that means there's limited options to mitigate constraints on production or liquefaction. So if you have a supplier default, or you have a breakdown and an inability to take gas at the liquefaction end, there's a greater exposure to loss on both sides. I think that makes the hydrogen industry at the moment difficult to project finance. So I think we're quite fortunate to have consortium members represented by large Japanese trading houses that both have the financial capacity to fund the project, but also government financing options from Japan, and a customer base that is readily created through the existing energy demand that are serviced by the consortium members and their customers in Japan. Another key difference is that while natural gas can be produced by depleting reservoirs as demand requires, you essentially bring gas out of the ground as you need it. The hydrogen production really depends on the power price. In Australia, we have volatile power pricing, in a national electricity market. So the direct connection of solar basically allows for a very low cost production without network transmission charges, but you're only doing that when the sun shines, when the resource is available. So you do need to marry that up with a storage capacity. And then, given that, storage requires compression, which entails cost. So you need to back that up with alternative and well-hedged power supplies from wind and solar, or from which will come off the grid. So essentially what you're doing is you're acquiring power under power purchase agreements with wind and solar developers to essentially green your grid supplies. You also have to factor in the possible use of the electrolyzer in demand management and frequency control functions within the national electricity grid. So one benefit of an electrolyzer is that it can be powered up and powered down rapidly, and that can be used to stabilize the grid. And that's an actual service for which the hydrogen production plant can achieve additional revenue. So one question we're really wrestling with is how much freedom can be afforded to that hydrogen producer or the seller to produce and supply according to production cost variation in the grid. And a lot of that answer comes, it'll translate into the nomination mechanisms in the gas sales contract. But it may be that we can build quite a bit of freedom into that production schedule, depending on how much storage is available at the production facility, at the liquefaction facility, and through the shipping schedule. So maybe rather than a daily gas production, we'll be looking at a weekly or a monthly gas delivery obligation that will allow the producer quite a bit of flexibility to schedule production according to the energy price fluctuations. And then the last point I'd make is just like Wolf was saying, we have an absence of hydrogen-related regulation at the moment. The national energy laws, or national gas laws in Australia regulate third-party access to gas pipelines, and the country is presently considering amendments to expand the scope of our national gas law to include what they'll call covered gases, which will include hydrogen and other alternative fuels. That might bring regulated access to hydrogen pipelines. But the actual regulation of pipelines from a tenure perspective is at a state level. And none of the states at the moment have hydrogen-specific tenure laws for pipelines. So you're relying on traditional easements, leases, or outright ownership to put pipelines in the ground. Interestingly, in Queensland, although our pipeline laws are aimed at only natural gas, the safety aspects of them will apply to hydrogen. So there is partial regulation. But the pipelines actually also present another issue, and that's that the volatility of hydrogen makes existing gas pipelines of questionable value for hydrogen. They certainly aren't suitable for the storage of gas in the same way that natural gas can be stored in a pipeline. So there's a bit of a volatility and a safety risk associated with it. The other thing we lack is a revenue hydrogen, and I have no doubt that our government will look at with how it can levy hydrogen production, and my personal guess is that may come through a water price or a levy on water usage, but it could also come through some sort of export licensing or value-added tax. So that's yet to be seen, and very moment our government very supportive of the development of the hydrogen sector as a way to expand the industrial footprint of our industrial areas. So that is the time available where I'll leave it. So I'll stop sharing and bring back my screen. I can see if there's any questions, or happy to take any questions.